Execution of judgment. Requirement for the grant of an application for leave to execute judgment on the immovable properties of a judgment debtor. So now, this ratio is talking about execution of judgment on immovable property of a judgment debtor. So when a judgment has been gotten and the judgment creditor wants to enforce the judgment on immovable property like land, for instance, or property, house, how do you go about it? So that is what we are going to look at here. This publication or this authority is on that execution of judgment requirement for the grant of an application for leave to execute judgment on the immovable properties of a judgment debtor. And what the court said, the court held that the provisions of section 41 of the Sheriffs and Civil Process Law, cap S5, Laws of the Cross River State of Nigeria 2004, which is in pari material with section 44 of the Sheriffs and Civil Process Act, cap S6, Laws of the Federation 2004, provides as follows. It is sufficient if sufficient movable property of the judgment debtor can be found in Cross River State to satisfy the judgment and cost of execution. Execution shall not be issued against his immovable property, but if no movable property of the judgment debtor can, with reasonable diligence, be found in Cross River State, or if such property is insufficient to satisfy the judgment and the cost of execution, and the judgment debtor is the owner of any immovable property, the judgment creditor may apply to the court for a writ of execution against the immovable property of the judgment debtor, and the execution may issue from the court against the immovable property of the judgment debtor in accordance with the provisions of this law and any rules made thereunder. Now, the purport of the above is that there is strictly no condition precedent to the exercise of the jurisdiction by the lower court for the hearing and determination of the application of judgment creditor to attach the immovable property of judgment debtor. However, the laid down consideration in deciding whether or not to grant the application of a judgment creditor are: 1. That no movable property of the judgment debtor can, with reasonable diligence, be found to satisfy the judgment debt and cost. B. That even if such movable property of the judgment debtor can be found, it is insufficient to satisfy the judgment debt and cost. And C. That the judgment debtor is the owner of the immovable property upon which execution are sought to be levied. Thus, the affidavit of the judgment creditor must therefore contain evidence of particulars of attempts, efforts, and steps that have been taken to discover the judgment debtor's movable property in the state. So this is the case of Lido Presidential Motel Limited against Bank of the North Limited and others. So now, this is a knowledge that we have gained by reading this. So as a subscriber, you've seen that if you want to apply for execution of judgment on immovable property of a judgment debtor, this gives you the idea or the steps you have to take in order for you to enforce that judgment with that procedure. So I did not read this, I will not get to know about it. So this is the essence of subscribing and reading our post. I just want to emphasize one thing, that it is good that you subscribe so that when you read something like this, you get more knowledge. Now let's move further so that you see more of the things you can get when you subscribe and read the post or the authorities I'm posting here, because this case is very instructive. Now we go to the facts of the case. Now, the facts of the case. This appeal borders on the attachment of immovable property in execution of judgment. Facts. This is an appeal against the ruling of the High Court of Cross River State, Coram MO Energy J, delivered on 5th February 2018. On the 25th May 2009, the trial court entered judgment in suit number HC 54/2007 in favor of the respondent in the sum of 6,537,550 naira as special damages, 2 million as general damages, and 10,000 as costs. Now, dissatisfied with the judgment debtor, the judgment debtors appeal to the Court of Appeal in appeal number CAC 39/2010, wherein the Court of Appeal allowed the appeal in part and reduced the damages to 3,050,000 naira. Consequently, the respondent applied for a writ of FIFE to attach the immovable property of the judgment debtor, and a writ of FIFE was issued for the recovery of the judgment debt of 3,050,000 naira plus 740 naira as cost of execution. The said writ of execution was on the 11th of November 2012 executed on Nissan Primera car with registration number AH940DUK, 2 old television sets, 1 old center table, and 1 old executive chair were duly attached and subsequently auctioned. Now, the respondent thereafter brought an application wherein he prayed as follows: 1. Leave to issue a writ for the attachment and sale of the immovable property of the judgment debtors / respondent situate at number 71 Target Road, Calabar, in execution of the judgment of this court in suit number HC 54/2007, delivered on 25th of May 2009, as affirmed in the judgment of the Court of Appeal delivered on 25th of March 2011 in appeal number CAC 39/2010. An order for the attachment and sale of the land and building of the judgment debtors respondent situated at number 71 Target Road, Calabar, in satisfaction of the sum of 2,995,600 naira, only being the outstanding balance of the cost of execution and the judgment debt in suit number HC 54/2007 as affirmed in appeal court number CAC CA/C 39/2010, and for such further order or orders as this honorable court may deem fit to make in the circumstances of this case. In this case, now, in support of the motion on notice is an affidavit of 11 paragraphs, and on being served, the appellant as respondent also filed a counter affidavit of 22 paragraphs. After hearing parties on their respective affidavit evidence, the learned trial judge granted leave to the respondent to attach and sell the appellant's immovable property at number 71 Target Road, Calabar, in execution of an earlier judgment in suit number HC 54/2007. Aggrieved by the decision of the trial court, the appellant appealed to the Court of Appeal. Now, issues. This appeal was determined on the following issue, which whether the lower court was right to grant the respondent leave to attach and sell the immovable property situated at number 71 Target Road, Calabar, in satisfaction of the applicant's judgment debt and cost in suit number HC 54 2007 as affirmed in Court of Appeal number CAC 39 2010. Now, decision. On the whole, the Court of Appeal held that the appeal lacked merit and it was accordingly dismissed. Now, if you have read this, look at, if you are bringing an application like this in future, you see how to catch the order in your motion paper. Like here, because you know that first of all, you have to seek leave. And in second order, you have to ask for an order for the attachment and for further orders as the court may deem fit to make in the circumstance. So if you are reading this, you know that you are learning how to, you can also learn how to couch your orders in an application like this. If you have an application like this, you can also learn how to catch your orders. Like here, other one, and other one which talks about leave to issue a writ for the, so, and also if you have an appeal like this, you also learn how to catch your issues. So that is the essence of reading our post, because it helps you a lot and you can learn a lot when you read this. When you have a similar case like this, with what you have learned here, you can use it and prepare your case. That is the most important thing that matters a lot here, that when you are reading things or authorities like this, when you are reading authorities, you are learning a lot of things. You're not learning only what the court held, you're also learning how other counsel prepared his case in such authority. So that whenever you have a similar case in future, you can just come here for your reference and use it to prepare for your case. That is all I want you to understand. So if you want to read more about the case now, you have to read the lead judgment delivered by Mohammed Lawal Choibu. We'll stop here for further notice.